Now let us go for a legal passage at 120 words per minute. Get ready. Start. After considering all the submissions, the court, in its decision dated 21st March in All India Judges Association and others versus Union of India and others, passed some directions. We are presently concerned with the observations made in paragraphs 24 to 29, in which reference was made to the 85th report of the Standing Committee of Parliament recommending that there should be increase in the number of judges. Said committee had noted the judges to population ratio, and in tune with 120th report of the Law Commission, recommendations were made to increase the judges strength to 50 judges per 10 lakh people in the first instance. Recommendations made by Justice Shetty Commission were also considered, and recruitment to the higher judicial service in the cadre of district judges was also subject matter of directions. Soon thereafter, in its decision rendered by Brijmohan Lal versus Union of India and others, this court had an occasion to consider the issue relating to fast-track courts. The 11th Finance Commission had allocated 502 crores for the purpose of setting up a lot of courts in various states to deal with long pending cases, particularly session cases. On the basis of said recommendations, a note was prepared by the Department of Justice, Government of India, to set up fast-track courts. Challenges were raised in some high courts to the constitution of such fast-track courts, and the matter were dealt by this court in transfer petitions. In the state of Rajasthan, the matters relating to constitution of courts and jurisdiction of courts were dealt with by the Rajasthan Civil Courts Ordinance 1950, which consolidated and amended the law relating to civil courts in the state. Clause 6 of said ordinance dealt with classes of courts. Clause 8 dealt with power to fix number of district judges, while clause 10 dealt with the appointment of additional judges. In exercise of powers conferred by Article 233 and the proviso to Article 309 of the Constitution of India, the Governor of Rajasthan made the Rajasthan Higher Judicial Service Rules 1969 in consultation with the High Court in respect of the Rajasthan Higher Judicial Service for making appointments, postings and promotions to the cadre of district judges and to provide for other ancillary matters. However, appointments in excess of the strength indicated in Schedule 1 to 1969 rules were made on various occasions. By notification issued under the provisions of the ordinance and under Rule 6 of 2 of 1969 rules, 40 additional district and sessions courts were set up in the state for fast-track disposal of cases pending before the district judges. By another notification, 13 more additional district and sessions courts were set up under the aforesaid provisions of the ordinance and 1969 rules for fast-track disposal of cases pending before the district courts. Further, 30 additional district and sessions courts were again set up in pursuance of aforesaid powers for fast-track disposal of cases pending before the district judges. Thus, courts were created which are commonly known as fast-track courts, and officers from the cadre of senior civil judges were promoted under Rule 22 of 1969 rules to man these fast-track courts. It may be mentioned that though the decision of this court in Brijmohan Lal had indicated 3 sources from which the candidates could be appointed to man the fast-track courts in the state of Rajasthan, candidates were drawn only from one source, namely through ad hoc or officiating promotions to the persons from the feeder cadre, that is, senior civil judges cadre. There was no appointment of any retired judge or by way of recruitment from the bar. A notification was issued by the High Court notifying 19 vacancies for direct recruitment to the higher judicial service. Out of these 19 vacancies, 11 were shown as current vacancies while 8 were shown as backlog vacancies. A challenge was raised in this court by way of writ petition civil number 576 by the association submitting inter alia that there were no vacancies for direct recruits and as such the notification was invalid. It was also submitted that as on the date 220 officers were functioning in the cadre of district judges and additional district judges. The matters concerning regular promotion to be granted to the level of district judge, including whether those who were appointed as additional district and sessions judge under Rule 22 of 1969 rules were being considered by the High Court. A report on a committee constituted to consider said issues were submitted on 23rd August. The matter was then placed before the full court on and thereafter the matter stood deferred. Schedule 1, which is referable to Rule 3C and Rule 6.1 of the rules, deals with the topic cadre strength of the service, and Part A deals with district judge cadre, which enumerates various designations in said cadre aggregating to 223 and earmarks 10% reserve for leave, training, deputation, etc., thus taking the grand total to 245. Parts B and C of this schedule deal with senior civil judge cadre and civil judge cadre and set out the strength at 222 and 329 respectively. Schedule 2, which is referable to Rule 6.2 of 2010 rules, deals with topic strength of the service.